Welcome. We are recording. My name is Francis Shen, and I am a law professor at the University of Minnesota Law School. I co-direct the new Neurotech Justice Accelerator at MGB Neurotech Jam and serve as the founding director of the Dana Foundation Career Network in Neuroscience and Society, and want to start with a thank you to the Dana Foundation and the Career Network for supporting this program tonight. Thank you as well to our co-sponsors, the Center for Law, Brain, and Behavior, CLBB. You'll hear more about that in a little bit with Executive Director Robert Kinshef and co-founders and co-directors Dr. Judith Edersheim and Bruce Price. And we'll talk a little bit more about CLBB later. And thanks to my home base here, University of Minnesota Law School, and our Dean, Bill McGovern, for supporting all of this work. So tonight we're going to talk about law and neuroscience, and we'll get into it, but a couple of housekeeping bits. I'll put this in the chat as well. On the back of this, we have a new book. On the back of this notepad, I have written a number between 1 and 1,000. So if you're attending and you want to win a copy of the book, whoever's closest to that number, put your number in the chat between 1 and 1,000. Whoever's closest, I will send you this book immediately after the event. All right, so that's housekeeping. Next, we are recording this. It will be up on the website of the neuroxcareers.org Career Network site, so we'll circulate that around. And then the last bit of housekeeping is this is the new book. We're going to talk a little bit about it, Brain Science for Lawyers, Judges, and Policymakers. I'll put a link in the chat to the table of contents, but in brief summary, it covers the basic things that we and our co-authors, Owen Jones, Jeffrey Schall, Anthony Wagner, and Judge Morris Hoffman, think that would be most useful for lawyers and judges and policymakers. There are a gazillion intro to the brain books, intro to neuroscience books. They're all good, but they're too long and probably too complicated for the busy legal professional. So we've tried to distill what we think are only the most essential things, and we hope you'll enjoy it. But a book about law and neuroscience begs the question, why put those two together? And one of the topics that we cover in the book is both that there's a lot of potential promise from introducing neuroscience into the law, but also a lot of peril. And maybe, some would argue, no reason to do it at all. So we've convened tonight to talk broadly about law and neuroscience, and I'm really delighted to introduce our panelists, who are all astounding and have all thought about in different ways this intersection. What we'll do, so you know, get ready for your participation, audience, because that's coming up at about 6:30 Central, 7:30 Eastern. We'll spend the first half of the program sort of with panel discussion, talking about the expertise that our panelists bring. And then we're going to turn to you, your questions, your interests, your concerns, and we will end promptly at 8 o'clock Eastern, 7 Central. Okay, so let's get into it, and let me start by introducing all three of the panelists tonight. We'll start with the Honorable Nancy Gertner, who is Senior Lecturer of Law at Harvard Law School and former federal judge for the U.S. District of Massachusetts. She's also the Managing Director of the MGH Center for Law, Brain, and Behavior, which I mentioned before. She introduced the first law and neuroscience course at Harvard Law School, and it is the oldest continuously taught neurolaw course in the country. Graduate of Barnard College and Yale Law School, also an MA in political science from Yale University. She's taught at Yale Law for many, many years in sentencing, comparative sentencing. We had the pleasure of co-teaching a criminal law course there. Was appointed to the bench in 1994 by President Clinton and has won so many awards, I can't list them all, but I've picked one. In 2008, she received the Thurgood Marshall Award from the American Bar Association section of Individual Rights and Responsibilities. She was only the second woman to receive this award. The first was Justice Ginsburg. I think that gives you a sense of the type of company Judge Gertner keeps. And you have probably seen her, or you will see her after tonight, in newspapers, on MSNBC, on the radio. Even tonight, you were doing double duty with events. So thanks for being here, Judge Gertner. We also have another judge, the Honorable Julie J. Bernard, who was appointed to the bench in Massachusetts in 2002 and serves as an Associate Justice of the Massachusetts District Court. She is an Access to Justice Commissioner and Chair of the District Court Alternative Dispute Resolution Committee. is also a trustee of the Flashner Judicial Institute, which we're going to hear more about a little bit later, and served as previously as the first justice of the Brockton District Court and member and chair of the Massachusetts Commission on Judicial Conduct. Before joining the bench, she had worked both in the public and private sector, including the Committee for Public Counsel Services, Massachusetts Bay Transportation Authority, and many other places. She's a graduate of the University of Pennsylvania and Boston College Law School. And I had the pleasure of working with Judge Bernard and her colleagues at the Flashner Institute this past year on what, for me, was the most innovative and, I think, effective judicial education program at the intersection of neuroscience and law. And look forward to hearing more about that. Finally, we are joined by Professor Perry Moriarty, who is an associate professor at the University of Minnesota Law School, my colleague here, where she specializes in juvenile justice, criminal justice, and race in the law. She teaches in those areas and co-directs the Child Advocacy and Juvenile Justice Clinic. She's a national expert on juvenile sentencing and policy. She's co-authored the leading juvenile justice casebook, and she has multiple times, we've had a great time talking about it, leverage neuroscience in cases for really amazing outcomes, including an outcome, I'm sure you'll talk about this case, where our current governor of Minnesota, now vice presidential candidate, Governor Walz, cited neuroscience in his decision to commute a sentence. So we'll hear more about that. Professor Moriarty is a graduate of Brown University and New York University Law School, and while I didn't plan it exactly this way, has Boston roots too, previously working at Ropes & Gray, and was also an attorney with the Youth Advocate Division, also of CPCS, Committee for Public Counsel Services in Roxbury, Mass. So it's great to have all three of you here. And I'd like to start with kind of a broad question, which is, what do we think about law and neuroscience? I guess more to the point, I'd like each of you to help from your perspective, whether on the bench or in the trenches in the courtroom, help us think about potential promise, concerns, limits, perils of introducing neuroscience in the law and especially in the courtroom. Judge Gertner, maybe we can start with you.
Sure. Well, let me start with why the promise, if you will. I was a judge for 17 years, and I sentenced people to sentences which often were unfair, unjust, and disproportionate. Part of it was the punitive nature of federal guidelines, extraordinary mandatory minimums, and simply the way the laws were structured. The kinds of things that I saw, which I couldn't then act on, but which people can now, were very troubling. A large number of the men I sentenced in particular were addicted, had substance use problems, had trauma in their background, had childhood experiences which were unbelievable. The coterie was mostly people charged with drug crimes. And all of this was unaddressed and not dealt with in the sentencing. In the United States, I found in my teaching and in my judging, you couldn't make an argument that this was simply wrong on its face, that we shouldn't be treating people like this, that this was, that we were basically not paying attention to the things that would help them, would predict a good outcome in their lives, or things that may be part of the reason why, factors that were part of the reason why they were in the federal criminal orbit to begin with. What neuroscience offered to me, which was extraordinarily interesting, and I worked with Dr. Edersheim and the Mass General Center for Law, Brain, and Behavior, was that while we can't talk about morals oftentimes in sentencing, we can't talk about values in sentencing, but we can talk about facts. And the decisions in the Supreme Court about the adolescent neurodevelopment based on neuroscience made an enormous difference. The Supreme Court couldn't talk as other countries did about why it's wrong to sentence juveniles to life without parole, but they could talk about the juvenile brain. And that opened up the door to talk about as much as we can, the impact that trauma has on the brain, the impact addiction has, solitary confinement, lengthy imprisonment. It changed the debate to a debate about facts rather than a debate about values. There are limitations of that debate. The MRIs on which much of the analysis was based or offer averages, don't really tell you about an individual person. But we legislate with averages. When we decide what the cutoff point for life without parole before the Supreme Court decisions, we were making generalizations, averages in a sense, based on nothing. Averages, generalizations about adolescents, generalizations about what they could or couldn't do. And what happens here is essentially dealing in categories. And the neuroscience could help you understand those categories in a much more substantial and fact-based ground. When we talk about confessions, juvenile confessions, we could talk about the ways in which the juvenile brain can deal with things like, do I think I'm in custody or do I not think I'm in custody? Their amenability to suggestion, etc. When we talk about solitary confinement, we could talk not about how much people are harmed by solitary confinement, but we can in fact evaluate what solitary confinement does in the average person and then abstract from that. Individual sentencing was a little bit more difficult because neuroscience didn't really tell you about the individual. It could tell you about individual brain impairments, but couldn't really tell you meaningfully about the averages that you saw in MRIs. Francis can explain that more. But on the other hand, so much of sentencing was based on generalizations and tropes that made no sense in any event, and neuroscience could inform that discussion. In particular, we've talked in the class about the impact of trauma. And almost everyone I sentenced was either the victim, witness, or perpetrator of violence. And so the question was, how do you get that to figure into our sentencing calculus? And the observations of neuroscience help with that. And then I'll stop after this. Adverse childhood experiences, which are not just, as an early version of West Side Story would talk about, rotten social background. I can do the song, but nobody wants me to do that. But rotten social background, I mean, what's the impact of all of this? Not just, what's the impact of all of this on school advancement, on forming meaning. In short, neuroscience, whatever its limitations were, informed the discussion about sentencing in a way that had never happened before, and there's still much more to talk about. So for me, it opened up really a number of doors. Dr. Edelstein, Dr. Kinshirf, and I co-teach law and neurosciences. Francis floats in and out periodically. And the whole idea of the course is to identify, in a sense, what the and is: neuroscience and addiction, neuroscience and solitary confinement, etc. How the science, how the evidence can inform how we evaluate these things. So that's why I'm the managing director of the Center for Law, Brain, and Behavior. And it has really enriched what I do and what I write about.
Thanks, Judge Gardner. Judge Bernard.
I think there is, for state court judges, there is so much promise in neuroscience and law. And as you said, Dr. Shen, we had a fabulous program that we developed together that was so impactful for state court judges last year from all trial court departments, where we saw that neuroscience impacts not just sentencing, but almost all decisions that state court judges made in both the district court, superior court, juvenile court, probate court, sentencing, bail decisions, detention hearings, mental health hearings. It makes judges more discerning consumers of the information that we receive. It helps us understand the information that we're receiving and making more informed decisions about the people that appear before us. I've been a judge now for over 20 years. I work in the district court department, and we handle every type of proceeding that you can in the state court. And over the years, so as society has changed, we see more mental health, we see more trauma, we see more addiction, and it has such neuroscience has such an impact on the proceedings that come before us. So the course that we designed with the help of the Center for Law, Brain and Behavior, with the doctor's assistance, and with the assistance of judges in the variety of departments, we looked at trauma, we looked at the aging brain, we looked at cannabis use, we looked at discussed those issues and how they impact our work in the courtroom, and saw that there's such an tie-in and overlap in how we can use that information. And as Judge Gertner was saying, these are facts that we can use that can inform the decisions that we make. And we need this information. And at Flashner, which is one of an organization that does a majority of the judicial training for Massachusetts judges, we got an overwhelming response from people, and they continue to write that this has been such an impact on the way that they do their work. It has impacted the way that they view things, not just expert testimony, but just every day, and how they handle their proceedings, how they view the evidence that they receive, because they are more discerning in how they view the evidence that is before them, the information that they receive. So this is an important part of our judicial work. And I think that there needs to be more instruction for judges nationally on this work, to understand what this means and how it impacts their daily work in the courtroom.
Thanks, Judge Bernard. Let's go to Professor Mor Ari.
Okay, thank you so much. And thank you very much for having me. I'm going to focus, because it's what my clinic focuses on, use of, I'll just say broadly speaking, scientific evidence or scientific data on the development of the adolescent brain in advocacy around the punishment of young people. And when I say young people, I mean those under 18, but actually those who we now call emerging adults, those between 18 and 25 roughly. And just to give you a sense of the role that, I'll just say the emerging body of increasingly sophisticated neuroscientific data that we've gotten has played on practice, there's kind of a before and after, at least for me. And that is before the US Supreme Court's trilogy, Roper, Graham, and Miller, really between 2005 and 2012, and then after. I began working with youth clients really in the late 90s and early 2000s at sort of the tail end, or at least we're still at the height of the do the crime, do the time super predator era of really magnified punishment. So the 1990s really was this era when every state in the country ratcheted up its punishment of everyone, irrespective of age. And then came, the turn of the century and this series of cases where the US Supreme Court said, actually, the Eighth Amendment prohibits states from imposing certain punishments. The death penalty for those under 18, life without parole for those under 18 who have not committed homicide, and then ultimately mandatory life without parole for those under 18. And this trilogy really opened up this arena for advocates to utilize what I'll say writ large brain science, but to make arguments about the reduced culpability of youth in a whole range of settings. It gave us a permission structure and a vocabulary, and in doing so, allowed us to use, not in a sophisticated way as folks who are practicing neuroscientists do, but allowed us to use scientific research on the behaviors and brains of children to explain why they may engage in certain criminal activity, and allow us also to make arguments about why they are more amenable to rehabilitation as a result. So we've used it in competency hearings. We've used it in adult certification hearings. We've used it in sentencing and resentencing proceedings under Miller. We've recently, and I testified on behalf of this bill, changed our first-degree murder sentencing statute in Minnesota to allow anyone sentenced as a child to prison to become eligible for release after 15 years. And our ability to rely on the U.S. Supreme Court's framework and trilogy of cases, but also to ground our arguments in what we now know about the developing brain, was really instrumental in doing that. We've also made arguments about conditions of confinement for youth, what our detention centers should look like and what they shouldn't look like. And I'm guessing Professor Shen can shed more light on this, but there's certain environments and types of confinement that are certainly not conducive to healthy brain development. It's really helped us to advocate for doing away with solitary confinement in certain contexts. We're now using it in retroactive parole hearings that are stemming from the laws we've rewritten. So I think this is all in the category of promise, not really pitfall. There are certainly pitfalls associated with it. I mean, one, of course, and I think Judge Gertner mentioned this earlier, this notion that you can utilize group data to reach, individual determinations about any one person is certainly imperfect and imprecise. Of course, we draw these lines all the time. And so for those of us that have been trying to push back against this rigid line at 18 or no line at 18 at all, it's very helpful to be able to say, well, actually, there are discernible differences that matter and dictate behavior. But and I'm looking at Professor Shen, who's the scientist here, certainly more than I am, this G2I group to individual data carries with it pitfalls. And I certainly wouldn't want to walk into court with the onus sort of being on me to present a brain scan of my client every time I'm arguing for some form of reduced culpability or mitigation. So I imagine there's a slippery slope that we could find ourselves going down if we didn't erect some guardrails. But the bottom line is this. I mean, I'll sort of, I'm not here to plug this book, but it's fantastic because those of us going into court to argue on behalf of young people, young clients, particularly in more serious criminal proceedings, need something to open up and to ground our discussions. We need to have in front of us an ability to explain why it is certain behaviors are more prevalent at certain ages and why they then drop off at other ages. And being able to be fluent in the vocabulary of neuroscience is critical. So I'm thrilled to have the book. I've actually now been asked by several colleagues if we can have more copies.
I agree. It is very readable. And I do think you need to, I do a lot of mental health proceedings. It's helpful getting reports and MRIs to be fluent in the vocabulary that you're reading and the scans and things like that. It's helpful during the proceedings to understand the vocabulary.
Professor Mor Ari, can I ask one question about one of the cases that I know you've many cases, but the Burell case? Maybe you could just tell us a little bit about that, because it was an individual commuted sentence, but the science was present there. Governor Walz cited it amongst other things. There are also many other compelling facts, but could you just say a word about how you navigated that on the ground, why you chose to add as a strategy the science, and kind of how you just navigated the problem you just laid out?
No, absolutely. I mean, without going too far into the Burell case, because unfortunately, if you search mine Burell right now, there are articles in various websites because the case didn't involve Governor Walz. This was someone who was sentenced to life plus a consecutive lengthy sentence for a homicide that took place in 2002, who's always claimed innocence. And it became a sort of hot button case during the 2020 presidential election, because several politicians had been part of it at the outset. And Mr. Burell found himself before our Board of Pardons, which is comprised of our governor, our Attorney General, Keith Ellison, and the Chief Justice of the Minnesota Supreme Court. And even though he was claiming innocence, the work of the Pardon Board really is about redemption, classically. This notion that you can look at someone, you can look at the time they've done, you can look at who they were at the time they arguably committed their offense, and make a determination about whether they have served enough time and deserve to be returned to their community. And at the time, Mr. Burell had done 18 years, and he had submitted an application of his own based on innocence. We supplemented that application, and I know I certainly conferred with Professor Shen at the time to say, in fact, his sentence itself, this life sentence in Minnesota is 30 years to life, plus another 15. So he was serving essentially 45 years to life for something that happened when he was 16, is inherently excessive based on what we now know about developing brains. So, even assuming arguendo that he had done this, which, we claim he hadn't, the sentence that he was given is disproportionately severe to his relative culpability. He was with 2 adults at the time, according to the prosecutor. But the arc of his sentence itself shows that, in the first few years he had some bumps, but over the remaining 15 had grown more and more mature and had effectively aged out of anything that someone might call criminogenic within the facility. And in the hearing itself, the governor did cite to that portion of our sort of supplemental submission to say, I buy into this stuff. I mean, he said it as Governor Walz does. I believe this stuff. I think it matters. And, to me, he's done enough time. And the notion of enough is so arbitrary in its own right. I mean, I'm sure the judges can speak to sentencing more eloquently than I can, but it is fairly arbitrary in its own right. And being able to say, this person deserves less from the get-go because of who they were at the time and who they have the ability to become.
Thanks
And
for
so
that.
his sentence was commuted.
Yeah, on the topic of sentencing, Judge Curtin, I want to turn back to you. You run with the Federal Judicial Center and the Center for Law, Brain, and Behavior, the FJC Harvard workshop on science-informed decision-making. And I'm wondering if you could talk a bit about that workshop and how, as a judge, you take all these considerations, including the science, working within, the constraints that you have, the sentencing constraints. What does science-informed decision-making and science-informed sentencing look like? How do you do it?
It's interesting. It's an interesting question. I think about what's the alternative, which is, what does sentencing based on nothing look like? Sentencing based on air, sentencing based on the seat of your pants, which is essentially what we do. Sentencing based on retribution, where sentencing based on retribution has no upper limit, because what is retributive is endless. So what we try to do is, first, the program initially grew out of pretrial diversion programs, which is, what do you do with people oftentimes who shouldn't have been arrested in the first place? But how do you create a program so that they don't enter the criminal legal system? They don't enter it at all if you can. And those programs have developed across the country, federal and state, trying to divert people from the criminal legal system. Those programs, by the way, are terrific, but they're oftentimes overwhelmingly people who shouldn't have been involved at all, shouldn't have gotten arrested at all, or white, and don't represent the majority of people who wind up, at least on the federal side. Then we also talked about neuroscience. We talk, these are mostly federal judges, but it's not just federal judges. It's probation officers, pretrial service officers, Let me just describe. So we do pretrial diversion, and then we do reentry issues. And more recently, we started to talk about what we've described as ordinary sentencing. And the way this is structured is that federal judges come with the probation officers that they work with. Sometimes public defenders are involved, or sometimes prosecutors. That has varied. And then we not only do lectures, as we've done in the Flashner Institute for state judges, but we actually bring in, we do hypothetical cases, because sentencing is not about abstraction. It's a clinical issue. What do you do in an individual case? Experts to talk to the judges about how the neuroscience can apply in that case. Again, in much the same way that doctors will consider science and the breakthroughs in science in what they do. So there'll be a hypothetical sentencing, and the judges will then sentence, and we will talk about what the sentence should entail. And there will be experts who'll sit, psychiatrists, psychologists, neuroscientists, who will sit with the judges and answer the questions that they have. Let me give you one small example. The recent hypothetical involved a young woman who was in her early 20s, had been addicted all her life, virtually all her life. She's arrested on a drug charge, and the judge realizes that she needs treatment. And so the judge puts her in an inpatient treatment facility. And as the pre-sentence report says, she absconds. And the pre-sentence report was all about how, oh my God, we gave her a chance and she blew it. All of the neuroscientists, all the psychiatrists, all the psychologists in the room said, what? She was in her early 20s, been addicted of course she would abscond. Relapse is part of the treatment. It is not a moment of judgment. It's certainly not a moment of judgment to return her back as if she had not tried and worked on this. So the program lets judges in a really academic setting, informs what it is they do, so that they can base their decisions not on oftentimes our intuitive sense of punishment, but base their decisions on science. And we do that with respect to all the aspects of neuroscience.
Judge Bernard, before we open it up to questions, I wondered if I thought we'd mentioned the Mattis case, which is a Massachusetts state case. Probably those of you on the call may not know it. Just decided in January, so kind of still hot off the press, in which under the Massachusetts state constitution, there is now a ban on life without parole for those not under 18, but those under 21. And I'll put a link in the chat for everyone. It was a notable decision because, my goodness, there was a whole lot of neuroscience in the decision. There's a whole lot of law too. And the dissent in particular, focused a lot on the law, but there was almost agreement on the science. I don't know how much you want to talk about that case or specifically, or just more generally. How does a legal system sort of respond to new science? Because in some sense, there was the law, but this was a case really driven, my sense was, I don't know if you agree, by changes in the science. At least it seemed to me that's what the opinion was driven at.
It was groundbreaking, but long overdue. I think it was a recognition of what we all knew, but hadn't been stated in case law. Because I think everyone knew what has been stated in the scientific journals about the youthful offenders in that age group. We've all been trained on it, but it had been never stated in case law. So it was a welcome, I think, as far as the judiciary was concerned, was a welcome decision and recognition of in the juvenile justice and in the criminal legal world. It was a welcome decision. So I think it was a recognition of something that was long overdue and was an unspoken recognition by the judiciary. So, and I see Professor Moriarty's kind of shaking her head because we all knew that this was out there, but it had never been stated in case law. So, yeah.
Yeah, the experts in the case, one of whom was our colleague Robert Kinship
Yes.
at Center for Law, Brain and Behavior,
Okay.
and the other expert, Adriana Galvan from UCLA. Those were neuroscience experts, and on the developing brain. It's just sort of a landmark in a lot of ways,
Yes.
I think, and I suspect we'll see more of that type of litigation
I agree.
moving forward.
In the
Okay.
state courts, not in the federal courts.
Yeah,
Yes.
right.
Great.
Right,
Great.
absolutely. And I should, well, so let's move to questions. I've got a bunch more, but I get to ask my questions all the time. We've got a really nice audience here. So there are a couple ways you can ask your question. By design, this is a meeting format, so you can use the Zoom function, raise your hand, I'll call on you, and you can unmute and join the conversation live. If you're more comfortable, you can type your question in the chat or in the Q&A, and we'll take those. While we do that, while you gear up your questions, let me ask one more, which is what you would advise. We have a lot of, I think, aspiring lawyers or young lawyers or young neuroscientists who want to get involved. This is a really kind of new emerging field. It's not exactly clear what you do. I'm wondering what you tell your students, Judge Gertner, in your class, or Judge Bernard, or Professor Mor Ari, students or folks who want to get involved. Like, what would you recommend for someone who kind of sees that this intersection may have some legs, or just be interested in for even a single case for a client? What should they do? Just open up to everyone.
Well, I mean, I think you have to change the equation, particularly in the criminal legal system. The equation for the past 20, 30 years has been, how long should we sentence someone? As if that decision is the only salient decision you can make. And you need to change the equation for prosecutors, for lawyers, for judges as well, to what can we do? How can we address this? Of which punishment should be one last resort. And this is the way to change the equation, is to talk about neuroscience in the way that Professor Mor Ari did.
I can jump in here quickly. One of the things that's always astounding to me, I teach first-year criminal law and then also, clinical courses, is when I talk to students about what countries in Western Europe do when it comes to punishment. Not only the length of sentences in terms of confinement, but also the nature of the facilities that, some for young adults in Mecklenburg, Germany, for example, are co-ed, that people are able to leave and, have effectively what amount to be dorm rooms, that they are able to live as close to a normal life while not being able to leave a facility as possible. And there's a clip I always show of an expert in the Netherlands and then in Germany and someone in Norway. And they all say, even public officials say, 90 whatever % of folks are coming home. And in Western Europe, it's close to 100 at some point. Don't we want them to be the best version of themselves that they can be? And doesn't that mean something therapeutic instead of punitive? Doesn't that mean actually giving them hope that they will have life on the outside? All of these things, doesn't that mean, pro-social opportunities? And brain science tells us that matters, particularly for brains that are still developing. And we think about our own kids and what we would and wouldn't do to facilitate and enhance their development. Other countries actually take that into account. And so, one of the things that I would tell a student who's thinking about using this is always think critically, not just about what is, but about what could be. And you are trying to convince decision makers like Judge Gertner, like Judge Bernard, to buy into what it is you're saying would be best, not just for your client if you're advocating on behalf of someone, but for us as a society. And having the ability to say, it's not just me talking, and you don't have to pretend you're Western Europe because we don't like to do that here. But in fact, the science tells us that people age out of criminal behavior, that long-term confinement actually increases recidivism, all these things. And it's because this is what happens to the human brain along the way. And so this notion that you always have to step back and ask yourself whether what we're doing here is the right thing, and it's certainly not the only thing that's being done around the globe. I think that's a critical moment of inquiry.
Thanks. We've got a great set of questions lining up in the chat, and I see a couple hands. So we'll go to the hands first. I want to note as well, and I see Attorney Kaplan on the line as well. So definitely want to mention that the most use of brain science in the law is actually on the civil side. Brain injury litigation cases, Social Security disability benefit cases, and a range. And the book and a lot of our work is neutral with respect to how it's used. But I just want to flag that. In fact, the term was coined in the early 1990s neurolaw by an attorney on the civil side, Sherrod Taylor, who's a friend. I see our first question. We can invite Dr. Rollins to join. Dr. Rollins, I'll embarrass you for a second. Dr. Oliver Rollins, good friend, colleague, and now professor of science technology studies at MIT, newly arrived in Boston, and his book. You should also read Conviction, The Making and Unmaking of the Violent Brain. Great book. So thanks for joining. Great to see you. And floor is yours.
Thank you, Francis. So, Francis, I'm somewhat of a critic of some of this. And so one thing I do want to bring up is that I don't know, I kind of push back against the idea that this is averages, because this is not averages. This science is not an average of like the population. I mean, we can take the sense that we don't know what a normal brain is. Like, so therefore, how could we know what an adolescent brain is? Like, we're not talking about averages. Like, as the science comes into the courtroom or outside, we're not talking about averages. But I think the question that I'm really thinking about is the pitfalls. And I know this kind of came up a little bit. And one of the things I think about a lot with this kind of question around adolescence or youth, in a way that the Simmons case or any of these other cases have used it, and other social scientists have talked about this as well. While I totally agree on the moral side of this, I think a lot about what does it mean that we're using neuroscience to make this kind of category or reify this category of adolescence or youth in a way, in part because this is a social category. Like, we know, scientists know what this is because we have defined what this is by age within larger society. So my question really is, like, while can be used on the one end to, I think in the wonderful ways it has been used to help us kind of reduce sentencing for youth, what does it mean for those who are, quote unquote, have a mature brain, right? Does it make it actually harder then for us to make arguments about decisions about sentencing and all the things that Judge Gertner brought up for folks who are, quote unquote, have a mature brain? And again, these things, mature adolescents, are not necessarily averages, and not, like, all of the same things apply. But I'm just wondering, on that end, can you guys speak to, like, what does that mean for us in a larger sense if we wanted to kind of make these more moral arguments around sentencing for those who are not immature, or I'm sorry, who are not youth?
Great question. Panelists, I've got a thought too.
I mean, I'll say this. I think that being educated about trauma and its impact on, brain development. I mean, trauma it may start in youth, but it continues. It has an impact on your brain development, no matter what your age. Poverty, disparities that exist throughout your life. I mean, I think being educated as a judge, I know that I bring a particular lens to my work as a judge. And it impacts the way that I view the world. I think educating judges on the effects of trauma on brain development, no matter what your age, is important, and it will impact how you view the information that you received. As Judge Gertner said at the beginning, it's facts, and I think it impacts you whether you're youth or whether you're a mature defendant. So I think it has an impact. I don't know how you feel about that, Judge Gertner, but I think it's
Well, I thought you were going to say something different, Professor Rollins. I mean, yes, it has an impact, as Judge Bernard was saying, with respect to non-youth, because it transforms the individual in front of you from a criminal record and an offense into a more complicated picture. And that's a helpful and a good thing. On the other hand, the other side of the danger, the danger is when they have tried a brain science equivalent of an intransigent, hardened criminal, and starts using it, as we see this in death penalty cases, and tries to use that to say, tries to individualize in the way we try not to in sentencing, using neuroscience to individualize. But the other side of the coin is a dangerous side of the coin. There's no question about it. In addition, sometimes this happens in sentencing in general. The ubiquity of trauma in some of the constituencies that I was dealing with, the ubiquity of substance abuse can lead decision makers, legislators to say, throw the book away, we can't do anything. So there is a downside. There's no question about it. But for me, it was a question of taking individuals out of the preordained punishment boxes, and that was worth the risk.
Yeah, I'll jump in very quickly. And then, I mean, I think that is such a great question, and sort of what you're saying. And I'm actually happen to be writing an article about this with two friends who were incarcerated as youth and spent decades behind bars and are now out. And part of our conversation is about this notion of sort of youth exceptionalism and whether that necessarily implies, and we're looking at it through an abolitionist lens, whether that necessarily implies that those who don't fall into that category somehow deserve punishment, somehow are, the baddest of the bad, so to speak. And that's something we take really seriously. And I think it's an excellent question. The flip side of it is, this notion that as you kind of chip away, particularly when you're thinking about incarceration, as you destabilize, as you show people, as we're doing across the country right now, that, since Miller, 1,000 people have come home who were sentenced to die in prison, and have come home, and the recidivism rate is less than 1% in a lot of places. So, the flip side is it's not what you would want. You wouldn't want there to be sort of a confined line at the relief you can hope to obtain. And in fact, everyone's exceptional in different ways. This happens to be the argument that we can get across. But the hope is that while we're doing this, and, the world it hasn't stopped spinning, as all of these folks have come home, that there's a destabilization effect. But boy, is that a great question.
Yeah, I'll just chime in quickly to say first that specifically in the context of the developing brain, there is sometimes a tendency in legal context to pathologize adolescence. But I come back to a quote that my colleague, a neuroscientist, does when she comes and talks to my class. She says, "What do you miss most about being a teenager?" And everybody's got a long list. Because yes, there are things that when we write a legal brief for purposes of sentencing, it might seem to pathologize, but there are a lot of really cool things about being 15, 18, 19, 21, and taking those risks. So that's the first thing. And secondly, this connects to a question I see from Valeria Flint about, neuroscience. The question is, as a judge, how do you quantify the trauma inflicted on the victim of the crime? What about their families? What about society? Neuroscience also informs the negative impact of injustice on the innocent. And, certainly the book is really just kind of a down the line, here are things to know about the brain, how it gets used in the law. And I think, Oliver, Dr. Rolland, you're pointing to this. That's a social, well, I guess the neuroscience is also socially constructed, look who I'm talking to, but how it plays out in the law is so much affected by the existing systems and the individuals doing it. So we don't have time to go in depth, but Valeria, I like your question. I've actually written a lot on the victim side of neuroscience. In fact, it's what's got me into the field. But I see other hands up. I want to keep going, and we're going to have a hard stop at 8 o'clock Eastern. But let's keep going. Kiera, do you want to unmute and tell us,
Yeah,
introduce yourself, and then
of
come
course.
on in? Okay.
Hi, everyone. I'll run through quickly. My name is Kiera Irby. You can just call me Kirby. And I'm a recent graduate student with a biomedical sciences background and neuroscience background. So this is my first time delving in law.
Welcome.
Thank you. So thank you for having this meeting. So I have a quick question. How can people with neurodevelopmental disorders, like for example, autism, can get support from a legal perspective if they committed a crime due to displaying disruptive behavior? They may not be aware that the behavior that they're displaying is disruptive. And I know disruptive is like a big word to use. But say, they may get overwhelmed and they're just not aware and they may get overstimulated. How can they get legal support? Because I read a case where there was a boy who was autistic and he killed his 1-year-old brother, I think, or said something like arson or something to that extent. And when they interrogated him, he had different stories. So it's like, I know he was probably very overwhelmed, and it's like, how do you deal with that? That was my question. So sorry if that was too long or anything to that extent.
No apologies needed or accepted. That's a great question. Anybody want to chime in on that?
Well, on the state court side, I mean, that would end up being a not guilty by, he would be found not competent, not criminally responsible for his actions after a mental health evaluation in the state court. I do a lot of mental health proceedings, and that's what would happen with someone if they have that mental health issues. It's funny, during the course of the Flashner program with the Center for Law, Brain, and Behavior, I had a young man that appeared before me that was 18, who happened to, he didn't commit as serious a crime as you've stated, Kirby, but he committed a lot of minor misdemeanors. One was a felony behavior, and the DA in Plymouth County moved to hold him on bail. They actually moved for dangerousness, but I saw he had no criminal history, had never been confined. He really didn't have a criminal record. He was a recent immigrant to this country. And what bothered me was that he looked really, really young. He was 18. He was from the Dominican Republic, didn't speak very good English, very poor, but I was afraid to send him to incarcerate him. Now we're going through this neuroscience class. I ended up sending him for an evaluation. I did something kind of, I've been doing this for a long time, and I convinced his lawyer, who I knew, to send him on an aid in sentencing, which I won't get into it. But anyway, sending him on an aid in sentencing, we realized that he was the victim of trauma, had a 6th grade education, had been sexually abused. It was this long, sordid tale, didn't speak English well. The end of the story is that he didn't end up going to the Plymouth House of Corrections. We ended up getting him in a group home, getting some DMH services. His cases ended up getting dismissed. I thought at the end of the day, it was a win-win, because this is someone, if he had been incarcerated, I knew that it would have been, he would not have been the same person. It would have created a criminal that it just would have been the end of this boy's life, that he needed more services from the Department of Mental Health than to be incarcerated in Plymouth. So that often happens. But in your case, Kirby, that person would have ended up being found not guilty by reason, not responsible for the criminal offense. Gone through the mental health process, possibly committed through the mental health system.
Let's go quickly. I think we have time for one last question from Sophia Rosenberg. Do you want to unmute and introduce yourself and jump in?
Hi, I just want to start off with saying I don't have quite the extensive resume that everyone here on the panel does, or some of the students. I'm just an undergrad, but I do have a question. Um, it's kind of revolving around the topic of sentencing reform, like Judge Gertner was bringing up earlier. Given the evolving understanding or comprehension that we have of neuroplasticity and like the development of our brains over time, especially in relation to behavior modification and rehabilitation, do you believe that current sentencing practices, the ones we have today, modern day, adequately account for an individual's potential for cognitive change over time?
No,
Judge Gardner, you want to take that?
no, not at all. I mean, the in the 1980s and 90s, we all went particularly punitive. Death penalty was re-implemented on the federal side in 1994. Mandatory minimum started on the federal side. The conversation was only about the length of sentences and criminal records. And we have begun to change that conversation in the way that we talked about. But as I have written in the books that I have, the habits of mass incarceration die hard. And they are confronting this new vocabulary and new image about individuals, but they die hard. I'll give you one short example. I know we're at the end of our time. Originally, we went very punitive because of an increase in the crime rate. So that was sort of understandable. People got hysterical about an increase in the crime rate, even though the crime rate went down and sentences didn't change. Crime has been going down now, and the political discussion is about carnage in the streets. And so how do you have a society that essentially is, this argument is going on fact-free. And what we're trying to do is introduce some facts into the equation. So it's made a dent in important courts like Judge Bernard's courts, in the federal court to a degree, but we need to have this conversation more widely across the country.
Yeah, this all deserves more conversation. You can have it. You can find all of our colleagues in various places having that discussion. I want to end with just to quickly mention a question that comes from Sophia Diaz-Rodriguez, which is what ethical concerns should be taken into consideration when using neuroscientific evidence in court, and how can legal professionals ensure the evidence is sufficient while addressing these issues? There are a lot of ethical issues. I'll just mention one, which is using evidence before it's ready because it's fancy, or because in one particular case, it might help your client, but in the long run, introducing it and the way that precedent works in the law, there might be a backlash. And I'll end in a second. I'll say thank yous, but on that point, here's something we write in the book. It's one of my favorite lines in the book. Given that neuroscience cannot currently answer most legal questions, one might ask why legal actors need to bother at all with its details. Why doesn't this primer consist of one sentence, not yet ready? So we have several answers. The first is that we have found that most tend to actually overstate, not understate the neuroscience. So this sort of equips, whether it's a judge or a lawyer, to push back against some of the stuff they see. Second, there are some really important issues. Attorney Kaplan works in these issues where, in fact, brain science is responsibly being used every day in the courts. And so for those things, it certainly matters. Third, and this came up a little bit today, thinking about neuroscience as a lens to investigate legal doctrine can push that doctrine in important ways, even if it's not as admitted evidence. And then finally, and this is really the big reason, this book will be outdated in a decade, absolutely outdated, because the science is moving that fast, the cases are coming that quickly. This is like get in now at the ground level of neuroscience and law. On that note, I want to thank each of my three co-panelists who are definitely in at the ground level. They're innovating, they're pushing the bounds. Professor Mor Ari, Judge Gertner, Judge Bernard, thanks for being here. Thanks for being colleagues. Thanks to all of our participants. I'm sorry we couldn't get to all the questions. If you're a student, you're in the Boston area, you can come track us down at Mass General. If you're in Minnesota, you can come track us down at the University of Minnesota. And if you're anywhere on the web, you can find us on the website. The last but not least, I'm about to do the big reveal. Here's the number, 452, which means that Yoshada Das, please stay on the line afterwards. You guessed 446. You are our lucky winner. I'm going to send you a book. So thanks to everyone. I'll stop recording and hang out for just a moment for that. Thanks to our panels. Have a great night, everyone. See you around.
Thank you.
Okay, bye-bye.
Bye-bye.
Take care.